2011. Meaning and significance. Like any other modern state, India has two kinds of people, citizens and aliens. Citizens are full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence, do not enjoy all the civil and political rights. They are of two categories, friendly aliens or enemy aliens. Friendly aliens are the subjects of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly aliens, e.g., they do not enjoy protection against arrest and detention, Article 22. The Constitution confers the following rights and privileges on the citizens of India, and denies the same to aliens: 1, 2, 3, 4, 5, 6, 7. Right against discrimination on grounds of religion, race, caste, sex or place of birth, Article 15. Right to equality of opportunity in the matter of public employment, Article 16. Right to freedom of speech and expression, assembly, association, movement, residence and profession, Article 19. Cultural and educational rights, Articles 29 and 30. Right to vote in elections to the Lok Sabha and State Legislative Assembly. Right to contest for the membership of the Parliament and the state legislature. Eligibility to hold certain public offices, that is, President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India and Advocate General of States. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example, paying taxes, respecting the national flag and national anthem, defending the country and so on. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. Constitutional provisions. The Constitution deals with the citizenship from Articles 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the persons who became citizens of India at its commencement, i.e., on January 26, 1950. It does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, the Parliament has enacted the Citizenship Act, 1955, which has been amended in 1986, 1992, 2003 and 2005. According to the Constitution, the following four categories of persons became the citizens of India at its commencement, i.e., on the 26th of January 1950. 1. A person who had his domicile in India and also fulfilled any one of the three conditions, viz., if he was born in India, or if either of his parents was born in India, or if he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, became a citizen of India, Article 5. 2, 3, 4. A person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfilled any one of the two conditions, viz. in case he migrated to India before July 19, 19,481, he had been ordinarily resident in India since the date of his migration, or in case he migrated to India on or after July 19, 1948, he had been registered as a citizen of India. But, a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for registration. Article 6. A person who migrated to Pakistan from India after March 1, 1947, but later returned to India for resettlement could become an Indian citizen. For this, he had to be resident in India for 6 months preceding the date of his application for registration. To Article 7. A person who, or any of whose parents or grandparents, was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. Article 8. To sum up, these provisions deal with the citizenship of a. persons domiciled in India, b. persons migrated from Pakistan, c. persons migrated to Pakistan but later returned, and d. persons of Indian origin residing outside India. The other constitutional provisions with respect to the citizenship are as follows. 1. No person shall be a citizen of India or be deemed to be a citizen of India, if he has voluntarily acquired the citizenship of any foreign state. Article 9. 2. Every person who is or is deemed to be a citizen of India shall continue to be such citizen, subject to the provisions of any law made by Parliament. Article 10. 3. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Article 11. Citizenship Act. 1955. The Citizenship Act 1955 provides for acquisition and loss of citizenship after the commencement of the Constitution. This act has been amended so far 4 times by the following acts. 1. The Citizenship Amendment Act, 1986. 2, 3, 4. The Citizenship Amendment Act, 1992. The Citizenship Amendment Act, 2003. The Citizenship Amendment Act, 2005. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship. But, this provision was repealed by the Citizenship Amendment Act, 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, viz., birth, descent, registration, naturalization and incorporation of territory. 1. By birth. A person born in India on or after the 26th of January 1950 but before the 1st of July 1987 is a citizen of India by birth irrespective of the nationality of his parents. A person born in India on or after the 1st of July 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after the 3rd of December 2004 are considered citizens of India only if both of their parents are citizens of India or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. 2. By descent, a person born outside India on or after the 26th of January 1950 but before the 10th of December 1992 is a citizen of India by descent, if his father was a citizen of India at the time of his birth. A person born outside India on or after the 10th of December 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. From the 3rd of December 2004 onwards, a person born outside India shall not be a citizen of India by descent, unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government, after the expiry of the said period. An application, for registration of the birth of a minor child, to an Indian consulate shall be accompanied by an undertaking in writing from the parents of such minor child that he or she does not hold the passport of another country. 3. By registration, the central government may, on an application, register as a citizen of India any person not being an illegal migrant if he belongs to any of the following categories, namely sad face a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. B. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. C. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. D. Minor children of persons who are citizens of India. E. A person of full age and capacity whose parents are registered as citizens of India. F. A person of full age and capacity who, or either of his parents, was earlier citizen of independent India, and has been residing in India for 1 year immediately before making an application for registration. G. A person of full age and capacity who has been registered as an overseas citizen of India for 5 years, and who has been residing in India for 1 year before making an application for registration. An applicant shall be deemed to be ordinarily resident in India if I. He has resided in India throughout the period of 12 months immediately before making an application for registration, and E. He has resided in India during the 8 years immediately preceding the said period of 12 months for a period of not less than 6 years. A person shall be deemed to be of Indian origin if he, or either of his parents, was born in undivided India or in such other territory which became part of India after the 15th of August 1947. All the above categories of persons must take an oath of allegiance before they are registered as citizens of India. The form of the oath is as follows. I, A.B., do solemnly affirm, or swear, that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will faithfully observe the laws of India and fulfill my duties as a citizen of India. 4. By naturalization, the central government may, on an application, grant a certificate of naturalization to any person not being an illegal migrant, if he possesses the following qualifications. A. That he is not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens of that country by naturalization. B. That, if he is a citizen of any country, he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. C. That he has either resided in India or been in the service of a government in India or partly the one and partly the other, throughout the period of 12 months immediately preceding the date of the application. D. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in the service of a government in India, or partly the one and partly the other, for periods amounting in the aggregate to not less than 11 years. E. That he is of good character. F. That he has an adequate knowledge of a language specified in the 8th schedule to the Constitution 3. And G. That in the event of a certificate of naturalization being granted to him, he intends to reside in India, or to enter into or continue in service under a government in India or under an international organization of which India is a member or under a society, company or body of persons established in India. However, the Government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India. 5. By incorporation of territory. If any foreign territory becomes a part of India, the Government of India specifies the persons who among the people of the territory shall be the citizens of India. Such persons become the citizens of India from the notified date. For example, when Pondicherry became a part of India, the Government of India issued the Citizenship Pondicherry Order, 1962, under the Citizenship Act, 1955. Loss of citizenship. The Citizenship Act, 1955, prescribes 3 ways of losing citizenship whether acquired under the Act or prior to it under the Constitution, viz., renunciation, termination and deprivation. 1. By renunciation, any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Upon the registration of that declaration, that person ceases to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. 2. By termination. When an Indian citizen voluntarily, consciously, knowingly and without duress, undue influence or compulsion, acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. 3. By deprivation. It is a compulsory termination of Indian citizenship by the central government, if a. The citizen has obtained the citizenship by fraud, b. The citizen has shown disloyalty to the Constitution of India, c. The citizen has unlawfully traded or communicated with the enemy during a war, d. The citizen has, within 5 years after registration or naturalization, been imprisoned in any country for 2 years, and e. The citizen has been ordinarily resident out of India for 7 years continuously. 4. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. In USA, each person is not only a citizen of USA but also of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one set conferred by the national government and another by the state government. This system creates the problem of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions and so on. This problem is avoided in the system of single citizenship prevalent in India. In India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights of citizenship all over the country and no discrimination is made between them. However, this general rule of absence of discrimination is subject to some exceptions, viz. 1, 2, 3, 4. The Parliament, under Article 16, can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory, or local authority or other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as to Residence Act, 1957 and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provision for any state except Andhra Pradesh. 5. The Constitution, under Article 15, prohibits discrimination against any citizen on grounds of religion, race, caste, sex or place of birth and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in fees for education to its residents. The freedom of movement and residence under Article 19 is subjected to the protection of interests of any scheduled tribe. In other words, the right of outsiders to enter, reside and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. In the case of Jammu and Kashmir, the state legislature is empowered to define the persons who are permanent residents of the state and confer any special rights and privileges in matters of employment under the state government, acquisition of immovable property in the state, settlement in the state and scholarships and such other forms of aid provided by the state government. 6 The Constitution of India, like that of Canada, has introduced the system of single citizenship and provided uniform rights, except in few cases, for the people of India to promote the feeling of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes and ethnic disputes. Thus, the cherished goal of the Founding Fathers and the Constitution makers to build an united and integrated Indian nation has not been fully realized. Table 6.1 Comparing the PIO card holder and OCI elements of comparison. Person of Indian origin PIO card holder, overseas citizen of India OCI 1. Who? A person registered as PIO card holder under the Ministry of Home Affairs scheme dated the 19th of August 2002. A person registered as Overseas Citizen of India (OCI) under the Citizenship Act, 1955. The OCI scheme is operational from the 12th of February 2005. 2. Who is eligible? Any person who at any time held an Indian passport, or E. He or either of his parents or grandparents or great-grandparents was born in and was permanently resident in India as defined in the Government of India Act, 1935 and other territories that became part of India thereafter, provided neither was at any time a citizen of Afghanistan, Bangladesh, Bhutan, China, Nepal, Pakistan and Sri Lanka, or E. He is a spouse of a citizen of India or a person of Indian origin as mentioned above. A foreign national who I was eligible to become a citizen of India on 26 January 1950, or E was a citizen of India on or at any time after 26 January 1950, or E belonged to a territory that became part of India after 15 August 1947, or IV his/her children and grandchildren, or V minor children of such person. However, if the applicant had ever been a citizen of Pakistan or Bangladesh, she will not be eligible for OCI. 3. What is the fees? 15,000 rupees per or equivalent in local currency for adults. For the children up to the age of 18 years, the fee is 7,500 rupees per or equivalent in local currency. US $275 or equivalent in local currency. In case of PIO card holders, it is US $25 or equivalent in local currency. 4. Which nationals are eligible? PIOs of all countries except Afghanistan, Bangladesh, Bhutan, China, Nepal, Pakistan and Sri Lanka. PIOs of all countries except Pakistan and Bangladesh. 5. What benefits one is entitled to? 1. Shall not require a separate visa to visit India. 2. Will be exempt from the requirements of registration if his/her stay on any single visit in India does not exceed 180 days. In the event of continuous stay in India exceeding 180 days, she shall have to get himself/herself registered within 30 days of the expiry of 180 days with the concerned FRO. 3. Parity with NRIs in respect of all facilities available to the latter in the economic, financial and educational fields except in matters relating to the acquisition of agricultural plantation properties. No parity shall be allowed in the sphere of political rights. 1. A multiple entry, multi-purpose lifelong visa for visiting India. 2. Exemption from registration with local police authority for any length of stay in India. 3. Parity with NRIs in respect of economic, financial and educational fields except in relation to the acquisition of agricultural or plantation properties. No parity shall be allowed in the sphere of political rights. 6. Does she require visa for visiting India? Can visit India without visa for 15 years from the date of issue of PIO card. Can visit India without visa for lifelong. 7. Is he required to register with local police authorities in India? Yes, one time when the stay in India exceeds 180 days for the first time. Number 8. What activities can be undertaken in all activities except mountaineering, missionary, research work and visiting protected, restricted areas which require specific permit? All activities except mountaineering, missionary, research work and visiting protected, restricted areas which require specific permit. Notes and references. India. 9. How can one acquire Indian citizenship? She has to reside in India for minimum 7 years before making application for granting Indian citizenship. she may be granted Indian citizenship after 5 years from date of registration provided she stays for 1 year in India before making application. 10. Can it be cancelled? Yes. On certain grounds yes. On certain grounds. Note 1. The provision for Commonwealth citizenship was omitted by the Citizenship Amendment Act, 2003. Note 2. In 2011, the Government of India announced its decision to merge the PIO card and OCI card schemes into a single scheme. This new scheme is proposed to be called as the Overseas Indian Cardholders Scheme. In this regard, the Citizenship Amendment Bill, 2011, is under consideration of the Parliament. Table 6.2 Articles related to citizenship at a glance. Article number. Subject matter 5. Citizenship at the commencement of the Constitution. 6. Rights of citizenship of certain persons who have migrated to India from Pakistan. 7. Rights of citizenship of certain migrants to Pakistan. 8. Rights of citizenship of certain persons of Indian origin residing outside India. 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. 10. Continuance of the rights of citizenship. 11. Parliament to regulate the right of citizenship by law. 1. On this date, the permit system for such migration was introduced. 2. This provision refers to migration after the 1st of March 1947 but before the 26th of January 1950. The question of citizenship of persons who migrated after the 26th of January 1950 has to be decided under the provisions of the Citizenship Act, 1955. 3. The 8th schedule of the Constitution recognizes presently 22, originally 14, languages. 4. This will not apply if he is a student abroad, or is in the service of a government in India or an international organization of which India is a member, or has registered annually at an Indian consulate his intention to retain his Indian citizenship. 5. By virtue of Article 371d inserted by the 32nd Constitutional Amendment Act, 1973. 6. Article 35A in the Constitution, Application to Jammu and Kashmir Order, 1954. This was issued by the President of India under powers conferred on him by Article 370 of the Constitution.